In our lecture on the sources of the law, we discussed treaties and treaties as a source of the law. We talked about creation of a treaty and how a treaty comes into existence. We did not spend a lot of time discussing treaty withdrawal. Treaty withdrawal happens relatively rarely. However, it has been in the news a lot lately, and so therefore I thought I would supplement our previous lecture. Now, first of all, remember treaties come into existence in stages. So we discussed the creation process for a treaty. It starts with negotiation. Negotiation is where representatives of the member states or prospective member states meet together to hash out the details of the treaty, to negotiate the terms of the treaty. It's meant to be a give and take process. The negotiation, once it's complete, is followed by the process of signature. Now, signature is not entry into force. Signature simply means that this is the final version of the treaty. It's this version of the treaty that will be submitted to the member states for ratification. Ratification is the process by which the member states declare that they are going to be bound by the obligations of the treaty. At that point, the treaty obligations become binding legal obligations on the state, and thus the treaty is entered into force. So that's the creation process of the treaty. But of course, treaties are not perpetual. And we know they're not perpetual because if a member state was bound by obligations, even when it chose to not be bound by those obligations, that would infringe on the notion of sovereignty. Remember, sovereignty says a sovereign nation has complete authority over all affairs within its borders. So we know that treaties are not perpetual. They don't last forever. And in fact, a country can withdraw from a treaty. Now, under international law, a nation can withdraw from a binding international agreement so long as it does so in conformity with the provisions of the agreement, meaning most modern international agreements will contain provisions that both allow withdrawal and specify the conditions of withdrawal. So every treaty, pretty much every modern treaty, has a means of exiting the treaty and therefore removing the obligations contained in the treaty. Now, international agreements, however, typically require a period of advance notice before withdrawal becomes effective. There must be some notification to the other member states of an intention to withdraw from the treaty. This could be 6 months, as in the case of NAFTA. It could be 2 years, as in the case of the European Union. But there is generally some notice period. And the notice period is meant to provide other member states with the ability to plan for an agreement that does not contain one or more of the members. Now, another word that we hear a lot when it comes to international treaties is abrogation. An abrogation of a treaty is not quite the same as withdrawal, although you will see instances in which the words are used interchangeably. But there's actually a difference, and the difference is that abrogation of a treaty means withdrawal without following the agreement's protocol for withdrawal, meaning simply unilaterally refusing to abide by the obligations of the treaty. Now, countries rarely abrogate treaties, and you can understand the reason why is that if a country routinely leaves a treaty without abiding by the terms of the treaty, then that country would lose credibility, and other countries would not be so willing to enter into international agreements with a country that abrogates treaties. there's going to be a built-in cost that's going to factor into these types of situations, so that if a country abrogates treaties, other countries, even when making international agreements, will have to take into account the possibility of abrogation, and therefore the terms of the treaty will change. So countries rarely abrogate treaties because it's in the long term detrimental to the country's future, and especially the country's future ability to negotiate treaties. However, the legal effect of abrogation is pretty much the same as withdrawal, meaning if a country abrogates a treaty, the other member states have very little in the way of remedy. If it is a political treaty, there is pretty much no means of enforcement of the protocols contained in the agreement. If it is an economic treaty, something like the World Trade Organization or NAFTA, there are dispute resolution methods built into those treaties whereby member states who complain about the abrogation may be entitled to some compensation. So the legal effect of abrogation pretty much the same as withdrawal, except in the relatively narrow circumstance of an economic treaty that provides for dispute resolution methods. Now, of course, where we hear this from is, of course, the United States in recent years has begun to withdraw from treaties that it had previously ratified. Now, we return again to this issue of the United States and its treatment of treaties. The domestic law of the United States provides for different types of treaties. However, remember that for the rest of the world, a treaty is a treaty. So therefore, even though the United States divides treaties into these three different categories, for the rest of the world, it's a binding legal obligation. It does not matter what character the treaty has under United States law. We often hear about treaty ratification as part of the Constitution. The Constitution has a provision regarding treaties, allowing for the president to enter into treaties, but only with the advice and consent of the Senate. That Senate being that advice and consent constituting a 2/3 majority. However, although treaty ratification is part of the Constitution, not every international agreement is a constitutional treaty. Most international agreements take the form of an executive agreement. In fact, estimates are as many as 95% of the treaties that the United States has executed are actually executive agreements. Now, what's the difference between these three categories? Well, as I noted, a constitutional treaty requires ratification by a 2/3 majority in the Senate. However, this is virtually impossible to get. In today's polarized political climate, it is virtually impossible to get a 2/3 majority in the Senate for any political document, which is essentially what a treaty is. The only time we see this sort of majority reached is when it's a topic such as human trafficking, in which the political parties of the United States are able to easily agree on that. So we rarely see this ratification by a 2/3 majority simply because it's impossible, virtually impossible, in today's political climate. Therefore, the United States relies on executive agreements. These are agreements in which the President of the United States, the executive of the United States, agrees to be bound by the law, bound by international law. An executive agreement does not require any congressional involvement or approval. Now, sometimes a president may negotiate an executive agreement, but is concerned that Congress should be involved in the agreement. So they may choose to submit an executive agreement to Congress for its approval prior to signature. This is the situation with NAFTA. NAFTA was an executive agreement negotiated by the executive, but then submitted to Congress for ultimate approval. And Congress signed off on it, and therefore it became it was ratified and entered into force. Again, all of these three types, the constitutional treaty, the executive agreement, and what we call the congressional executive agreement, these are all binding international law. For the rest of the world, there's no difference between these three types of agreements. Which leaves us with this question of, can the United States president unilaterally withdraw from treaties? Now, this question of unilateral termination, meaning the president of the United States, without consulting Congress, unilaterally terminating a treaty, that's up for debate. And we have no definitive answer on this question. So, one school of thought would hold that an executive agreement treaty can be withdrawn as easily as any other form of executive agreements. Executive agreements, executive orders are routinely withdrawn once the president who assigned them has left office and has been replaced. And some would hold that these treaties, these executive treaties, can be withdrawn as easily as any executive order could be. And therefore, the president has the right to unilaterally terminate United States participation in the treaty and the United States agreement to be bound by the terms of the treaty. There's another school of thought, however, that says because a treaty is a law, and we know it's a law because of the supremacy clause found in the United States Constitution, the supremacy clause specifically states that international agreements are the law of the United States. So if you are a constitutionalist, you believe in the separation of powers are described in the Constitution, then the executive branch would have no ability to unmake the law without congressional approval. The separation of powers doctrine says that the United States president is there to execute the law, to ensure that the laws are followed, but the president doesn't get to make law, and he doesn't get to unmake law. So if you are a strict constitutionalist, you would argue that the president does not have this power. This is even more dramatic in the case of a congressional executive agreement like NAFTA. If in fact Congress has approved the agreement, has voted for the agreement, is it possible then that the president can simply terminate the agreement without input from Congress? Many would say that's impossible. Of course, in today's political climate, there has been much deference given to the executive's powers, and therefore, if this was ever actually litigated, my guess is that ultimately that first school of thought would win, that an executive agreement, this treaty, is just like any other executive order. So in conclusion, what do we know? We know treaties are not perpetual. They don't last forever. That treaties provide for withdrawal, and in fact they should provide for withdrawal, because of the doctrine of sovereignty, the idea of sovereignty. We know that the domestic law of the United States provides for different types of treaties, but we also know that it doesn't matter to the rest of the world. To the rest of the world, when the United States signs an agreement, whether it's a constitutional treaty or an executive agreement or a congressional executive agreement, they are all binding international law. And then finally, we learn that the question of unilateral termination of a treaty by the president is open. It is still up for debate. And that's it. Thanks for listening.